Respondent number 3 and 8.
Respondent number
3 and
appellant number.
appellant number 8. Appellant number 8 has already been deleted, I suppose. IA number 8483 of 18. You filed this IA? Yeah, IA number 8. Respondent number 3 का? हाँ. When did he expire?
They don't know the exact date.
Tentative.
No idea.
This IA has been allowed, this IA number 8483. By which order has it been allowed?
Order
This is for deleting the name of appellant number 8, appellant number 9, appellant number 10.
Order 18/9/2018.
Yeah. So that has been taken care of. Right? SA number 555 of 2016. An adjournment notice has been circulated. Mentioning that appellant number, respondent number 3 has expired. Similar adjournment notice was circulated on 13/10/25 also. Counsel for the appellant place was 4 weeks time. Post on 10th of December.
Item 22, second appeal 388 of 2017.
You are the plaintiff. Suit was filed for what?
Oh, clear the right text.
Just a moment. You had sought for a relief that notification of the suit line under section 29, 30, 31 of which act?
Of the Indian Constitution.
You wanted that notification should be declared inoperative and illegal. On what ground?
Leader commissioner, report of the leader commissioner may not be considered by the
Exhibited.
executive.
Exhibit number.
They mention the judgment page number 9, page number 13.
Page number.
Internal page number 9 and 13.
Internal page number 9. Okay, where is it mentioned?
Internal page number 9.
Exhibit 10 is the inquiry report of the advocate.
They progress.
Advocate commissioner has been examined as witness number. Please witness number. Who has exhibited it?
Journey. Independent witness examiner.
The pleader commissioner reports, the advocate commissioner reports, has to be exhibited by the same person. He has to be cross-examined. How do you rely upon this evidence? Merely because it has been marked as exhibit, it is full and final. इससे क्या मतलब है? उसको क्रॉस एग्जामिन कोई करेगा ना? A person has given a report. He is not to be cross-examined. Pleader commissioner's report is normally exhibited by the pleader commissioner himself. He is cross-examined.
Name of the step 2. Sister, father of the applicant number 1. Applicant number 2. He recorded in the file, step 2. I got it.
I'm not. What is the source of your title?
Settlement to settlement.
Registered document है.
सादा
1941 का सादा होता है. Who was the landlord?
खास किया मयूर.
Who was the landlord?
खास किया मयूर गवर्नमेंट.
Who was the landlord in 1941? From who was the landlord? आपसे नहीं पूछ रहे हैं, आप बैठे. किससे सेटलमेंट किए 1941 में? जमींदार का नाम बताइए.
Bhatteshwar Prasad.
Sorry?
Bhatteshwar Prasad.
Who he was a landlord?
He had granted Hukunama in favor of the grant.
Who was he?
He was Jamindar.
From where do you get this? It is not there in your plaint. From where did you get this? Plaint में तो नहीं है आपके.
On the basis of the Hukunama, demand was upheld in year 1955.
I just want to know from you that from where do you get that Bhatteshwar Prasad was the zamindar? Because it is not there in your plaint. कहाँ से पढ़ना है? आपको लगता है ये 50 पन्ना भी आप रीडिंग करेंगे? You want to read 50 pages? क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए हैं आप बताइए? कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ? 6.
Page number 11.
Page number
11.
and substantial question of law number
A, B, C.
only ABC.
A, B, C, D. Whether the
6 substantial question of law बनाए. All of them are you are pressing.
C, C, D, C, D, F.
C, D and F.
Whether the learner play while passing and doing completely Sada more than several decades. However, more than statistically clear, the plaintiff become right over the
So you are claiming adverse possession as well as title.
Adverse.
दोनों. हुक्मनामा से आपको आपको टाइटल चाहिए और लेंथ ऑफ पोजेशन से आपको एडवर्स पोजेशन चाहिए.
हुक्मनामा से मंजी में मेरा नाम है वो मंजी तो नाम से नोटेशन हुआ करेक्ट सिंस देन
रजिस्टर टू एग्जिबिट हुआ है.
रजिस्टर टू भी एग्जिबिट हुआ.
आपका लेंथ रेंट असेसमेंट का ऑर्डर हुआ होगा ना, तभी ना रजिस्टर 2 में चढ़ा होगा। इतना लेजरली मत देखिए भाई, आप अपना आर्गुमेंट करिए, सुन रहे हैं आपको। 50 पन्ना पढ़ने का परमिशन हम नहीं दे सकते कि पूरा जजमेंट टॉप टू बॉटम यहाँ पढ़ेंगे, ऐसा नहीं होगा। जस्ट टेल अस कि कौन सा इशू में कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ आपका बन रहा है।
Can we see issue of judgment? Page number 8 of judgment, original.
Yes, it's.
The pleading of the party, the following issue has been taken.
I've read it.
Whether the suit is maintained.
पढ़ लिया इसको, पढ़ लिया। 6 इश्यूज है।
लेकिन इसमें कहीं भी रेस्ट्रिक्टिव का जिक्र नहीं किया हुआ। लीडर को एडवोकेट लीडर करने का जो
इशू में थोड़ी जिक्र होगा
कि मेरे फेवर में इन्होंने रिपोर्ट दिया कि इनके ही पोजीशन में है, और जो कि प्लॉट नंबर 55 वो जो है कितना, उसमें 375 डिसमिल 375 एकड़, हम केवल अपने 61 एकड़ 225 मेरे फेवर में हुक्मनामा हो गया। ये इन्होंने कहीं नहीं दिया गया कि होल प्लॉट हैज बीन एक्वायर्ड बाय द फॉरेस्ट।
Your claim is on plot number?
Plot number 55.
Whose total area is?
Total area is 61.25 acres.
61.25 acres. You are claiming by hukum now.
Hukum.
Okay. And how much area are you claiming?
Only one.
61.25 acres तो टोटल एरिया हो गया ना।
टोटल।
आप कितना क्लेम कर रहे हैं?
नहीं, 61 में ये टोटल नहीं है, इसमें 375।
अच्छा,
प्लॉट नंबर 55 में
टोटल एरिया है
375। इसमें
आप 61.25 क्लेम कर रहे हैं। आपके में चौहद्दी है बाउंड्री?
हाँ, बाउंड्री दिया हुआ है इसमें।
बताइए।
इसमें नॉर्थ में है रंगरी प्रजापति, और नॉर्थ में है बाउंड्री पड़ती है, नॉर्थ में है
कहाँ से
पड़ती है,
कहाँ से पड़े?
जजमेंट सेकंड पारा का लास्ट सेकंड सेकंड second paragraph. The case of the plaintiff includes that the land situated in village Jharkhand under Chapter number 5, plot number 55, area 61.25, were recorded as the Mayaga land of this land, Lord Langar Shed. Total area of the full plot is 375 acres, and out of that the area 261.25 acres mentioned above as Rangi Prajapati in North Bombay, Bharti Kadim in South, Siman East में and Bodhi on the west. ये बात है। शेड्यूल ए में जियोलॉजिकल टेबल भी दिए गए थे। जो पंचू महतो के नाम से सेटलमेंट हुआ। पंचू महतो 3 भाई थे। पंचू महतो के नाम से ही सेटल किया। इसमें तीनों के नाम एक्सप्लेन कर रहे हैं। पंचू महतो 3 बच्चे के छोटे चले गए। और जो फर्स्ट जो बच्चे हैं वो गुरुचरण महतो बेटा। इनका एक ही लड़का। थर्ड है छोटू महतो। इनका भी 3 लड़का। टोटल
सेक्शन 80 का नोटिस दिया था?
सेक्शन 80 का नोटिस नहीं दिए थे कारण कि मेरे घर के सामने घर के चारों तरफ घर था।
एग्जेम्पशन मिला था?
144 एसडीओ की हाँ
एग्जेम्पशन मिला था?
एग्जाम्पशन तो नहीं मिला।
एग्जेम्पशन नहीं मिला था तो आपका सूट ही कंटिन्यू था। सेक्शन 80 पे फाइंडिंग है? मैंडेटरी है नोटिस सेक्शन 80 का। Either you can have the notice under section 80 and then file the case, or you can seek an exemption before the court to file the suit without giving notice under section 80, showing the urgency to the court. These are the only 2 recourses open to a person who is litigating against the state.
इन्होंने घंटा कर हम 144 के साथ एसडीओ की हम एसडीओ की हैं इन्होंने किसी भी प्रकार का मन गलत ये नोटिस जो प्रोड्यूस करने के लिए
Paragraph 5 and 6
Of the?
680 of the judgment.
5 and 6 of the
Paragraph 5 of the judgment,
trial court.
page 20.
criminal case has been lodged against our ancestor, and in all cases our ancestor are we highly equipped. Due to lack of the paper, that this paper is and this land is government forest land or land. इन्होंने कहीं नहीं दिए हैं कि जो प्लॉट नंबर 50 का 375 है वो पूरे फॉरेस्ट लैंड हम पूरा हम क्लेम नहीं करें केवल 61.25 out of the 375 that has not been considered.
एग्जेम्पशन इनको मिला था ये जजमेंट ही नहीं था। पेज नंबर 35। Issue number 5 is the main issue. Page 27.
This is main and vital.
पढ़िए पढ़िए जोर से पढ़िए तो सुनाई नहीं।
This is main and vital issue in the suit. it is well settled principle of law that plaintiff has to stand on his own legal. Plaintiff have come in the case that land issue twice settled to Hukum number dated 22/1/1941. Plaintiff guide issues of the Jamindari land receipt. It has not been mentioned anywhere in the plan that who settled the land in favor of me. That is name of the plaintiff has not
Name of the ex-landlord has not been mentioned.
has not been mentioned. Option 3 has been destroyed by the plaintiff as per consumer again for which is the basis of claim. The plaintiff over the suit land on what result of the gift voting appear that this document is in damaged condition and it is plain and not easily readable. However, it appears that the documents have been issued in year December 2000, which corresponds to 1943. Again, C is a Jamindari land receipt issued by Rama Raj. On pressure of this document, it appears that this land receipt has been issued to consumer and other on 15/10/41. Thus, it may become practical that there is a vital contradiction between the here.
Just hold on. What is the error in this? Samvat 2000 is equivalent to 1943. You have Zamindari rent receipt prior to this. How do you explain this? Zamindari rent receipt is issued only after issuance of Hukumnama, only after settlement. So court is saying that it is contradictory. How do you say this? Is this correct or incorrect?
After 1943, demand was opened in year 1945.
Zamindari rent receipt is Hukumnama followed by Zamindari rent receipt can be utilized to some extent. Hukumnama registered है क्या आपका? नहीं है ना? सादा हुकुमनामा का तो वैसे ही कोई वैल्यू नहीं है. But when it is followed by Zamindari rent receipt, it is used for certain purposes. Correct? And this is absolutely contradictory. Do you have any explanation to this? यहीं पे आपका केस डिमोलिश हो जाता है. Your entire case is based on a हुकुमनामा.
Our name was
आपका नाम कहीं भी चढ़ जाए इससे क्या?
government.
कोई फर्क नहीं पड़ता है इससे. रजिस्टर 2 से आपका टाइटल नहीं डिसाइड होता. जब आप अपना हुकुमनामा के बेसिस पे क्लेम कर रहे हैं तो हाउ डू यू जस्टिफाई दिस? रेंट रिसीट आपको पहले मिल गया.
एरर हो सकता है.
Error?
टाइपोग्राफिकल एरर हो सकता है.
सब्सटैंशियल क्वेश्चन ऑफ लॉ इस पर नहीं बन सकता है ना. आगे पढ़िए.
Exhibit 3 is Jamindari rent receipt issued by Rama Raj. On pressure of this document, it appears that this rent receipt has been issued to consumer and others on 15/10/41. Thus, it may become crystal clear that there is a vital contradiction between the year of Hukumnama and year of issuance Jamindari rent receipt. Therefore, both the documents that is Exhibit 14 and Exhibit 1C produced by the plaintiff come under the according to the plaintiff suit land, which is mentioned in the schedule A to the plaintiff is covered under Khata number 5, block number 55, area 61.25 acres of village Jharkhand, PS under the district chapter immediately Exhibit 14 that is Hukumnama produced by the plaintiff is unregistered documents and year of issuance of Hukumnama. I did not tell you here. issuance of the Mundari land receipt, hence in such circumstances when there is notification is yet to be. In respect of the suit land, which has already been issued by Governor of Bihar in the year 1953, declaring the suit land to be protected forest under. इन्होंने बोलते हैं 53 में गवर्नर का इशू हुआ कि फर्स्ट लैंड को acquire. Thereafter 1955 our demand has been opened.
गलती से wrongly issued a demand.
Under section 29 of the Indian Forest Code, I can't my share I will be told that the land was settled to none other than the plaintiff on video I give to that is satisfied with the order passed by AGM Chapter, case number 2003, 144. Under section 144 CRPC, it appears that the plaintiff number 1 government while first party in the proceeding and the second party DFO, not Chapter. And further appears that first party that is plaintiff of the instance should oppose the court of AGM with a case that they got the land in dispute through government purchase. According to the learned AGM, survey proper map and measurement report produced before him confirm the validity of said purchase. It is a matter of the surprise that the land plaintiff have not whispered in their reading that my purchase and that any purchase was issued by the plaintiff in respect of the suit land. Rather, they have come with a case that Bihar government has recognized the tenancy of the settling consumer over the land.
क्या बोलना है इसके बारे में? Your evidence is beyond the pleadings. You claim on the basis of hukumnama. That hukumnama has been doubted by citing reasons. Then there is a claim on the basis of parcha. It is never your case that there was any parcha issue. Plaint में है ही नहीं. Plaint के beyond कहाँ से pleadings? कहाँ से evidence देते हैं? इनका केस छोड़िए आप अपना केस
1494
उनका केस छोड़िए आप अपना केस आप सिर्फ अपना केस आप सिर्फ अपना केस बहस करिए you had come for a declaration of your title, correct? You show your documents for declaration of your title. Your basis is hukumnama. Hukumnama is under serious cloud. It is not a case where hukumnama is followed by issuance of rent receipt. It is a case where rent receipt is followed by a hukumnama. Reverse direction, ulta gati bhai hai. मुश्किल इशू नंबर 3 क्या है? इसका क्या रेलेवेंस है? आपका टाइटल नहीं होगा तो आप अननेसेसरी डिक्लेरेशन से क्या मतलब है? It is of no use. You have failed to prove your title. चलिए एपेलेट कोर्ट क्या किया?
सेम कोर्ट की है। सुप्रीम कोर्ट में कोई डिफर नहीं की है कहीं, कहीं भी चीज रखनी है, और neither he consider the report of the leader commissioner nor committee consider the
Both the courts have not considered
electricity and the government documents that is constituted.
They have not considered the pleader commissioner's report, exhibit 2 और exhibit 10
Exhibit 10.
और क्या नहीं देखे आपका rent receipt exhibit 1/C, exhibit 1/C ना,
1/C.
exhibit 1/C. आपका हुक्मनामा नहीं देखे, exhibit 14, exhibit नंबर बताइए. Exhibit 6. Okay. तो जो एग्जिबिट नंबर है लीडर 10.
हाँ, रिपोर्ट है 10. मैप है जो नीति द्वारा तैयार किए गए एग्जिबिट 11.
तो वो लीडर कमिश्नर के रिपोर्ट से आपको टाइटल मिल कैसे जाएगा? जरूरत नहीं है. Not required. Okay. Or the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 9/5/2017 within bracket decree signed on 24/5/2017 bracket 2 passed by learned district judge Roman 1 Jatra dismissing the civil appeal number 13 of 2008 and affirming the judgment dated 29/5/2008 within bracket decree signed on 5/6/2008 bracket close passed by learned subjudge 1 Jatra in title suit number 14 of 2003 whereby the learned subject had dismissed the title suit. The appellant has lost in both the plaintiff has lost in both the courts and is in second appeal before this court. The learned counsel for the appellant, while the suit was filed by the plaintiff seeking a declaration with regard to settlement of the for the following relief. इसमें है डिक्री है इसमें, ठीक है, पेज 40 में डिक्री है, उसी में से लेते हैं. The learned counsel for the appellant has submitted that the judgments passed by both the courts are perverse and hence a substantial question of law is required to be framed. He has submitted that the learned courts have not properly considered the hukumnama within bracket exhibit 14, rent receipt, a hukumnama issued by the ex-zamindar within bracket exhibit 14, rent receipt issued by the ex-zamindar within bracket exhibit 1 by C, leader commissioner's report within bracket exhibit 10 and the map appended to leader commissioner's report within bracket exhibit 11 and register 2 within bracket exhibit 6 the learned counsel has submitted that the plaintiff was claiming title over the suit property on the basis of hukumnama and rent receipt was also issued by the ex-landlord. He has further submitted that the name of the plaintiff was also mentioned in register 2, which was entered upon abolition of zamindari in the year 1955. 1390. उसके बाद आपने रेंट दिया है?
हाँ, उसके बाद मैंने देते
कौन
हैं।
सा एग्जिबिट?
इसमें
एग्जिबिट बताइए. Which were government rent receipts, exhibit 1 to 1 by B and 1 by D to 1 by H. He has submitted that even the leader commissioner had submitted a report showing that the plaintiff was in possession of the suit property.
अभी तक हम पोजीशन में हैं.
He further submits that the plaintiff has continued to be in possession and is still in possession of the suit property. And no proceeding has been initiated to evict the plaintiff so far. Yeah. The learned counsel has further submitted that the plaintiff was claiming a portion of plot number 55, whose total area was 375, and he was claiming only 61.25 acres. The learned counsel has submitted that the plaintiff sought a declaration that the settlement of land through hukumnama in his favor was valid, but the aforesaid aspects of the matter has not been properly considered, and therefore the impugned judgment is perverse. That's it. After hearing the learned counsel for the appellant, this court finds that the plaintiff had sought for a declaration of settlement of land in his favor with respect to the suit land as valid, and also sought a declaration that the notification under section 29, 30 and 31 of the Indian Forest Act is illegal and inoperative, and sought a permanent injunction with respect to the suit property. The specific case of the plaintiff was that the property was settled, that the suit property was settled by ex zamindar through hukumnama dated 22/1/1941, and rent receipts was also issued by the ex zamindar. Which was subsequently followed by the rent receipt issued by the state. After entry, which was subsequently followed by the rent receipt issued by the state. As a demand was opened in the name of the plaintiff in Register 2 on 31/3/55. plaintiff नहीं है, ancestor of the
Ancestor of-
plaintiff, namely
Panchum.
Panchu है. This court finds that the defendants contested the suit and claimed that the property is a declared forest under the provisions of section 29 and 30 of the Indian Forest Act, and claimed that the suit property vested in the state of Jharkhand, the then state of Bihar, way back in the year 1953, by notification issued in the year 1952-53. It was their case that the land of plot number 55, area 61.25 acres, which was a suit property, was acquired by the Forest Department by virtue of the same notification, and therefore the property belongs to the Forest Department. And the Forest Department has planted trees over the property, and the property is still in possession of the Forest Department. The issuance of Hukumnama and the claim of the plaintiff was denied by the defendants. The learned trial court framed the following issues for consideration, para 11. Both the parties led oral and documentary evidences. The learned trial court offers of the view that issue number 5 was the most important issue in the matter, and by deciding issue number 5 as to whether the plaintiff has any right over the suit property. The learned court recorded that the plaintiff was claiming title through Hukumnama dated 22/1/1941 and Zamindari rent receipt, which was marked as Exhibit 14 and 1/C respectively. The learned court recorded that Hukumnama of 1941. 1941, the learned court recorded that upon perusal of the Hukumnama, the year was shown as Samvat 2000, which corresponds to year 1943 AD. And the Zamindari rent receipt was dated 15/10/41. The learned court recorded that there is vital contradiction in connection with the date of issuance of Hukumnama and Zamindari rent receipt. And Zamindari rent receipt was prior to the issuance of Hukumnama. The court recorded that the document Exhibit 14 and 1/C produced by the plaintiff came under claim. The court further recorded that the Hukumnama is an unregistered document, and the year of issuance of Hukumnama does not tally with the year of issuance of Zamindari rent receipt. And thereafter considered the notification Exhibit B with respect to the suit land which was issued by the Governor of Bihar in the year 1953, declaring the suit land as protected forest under Section 29 of the Indian Forest Act. The learned court also recorded that the plaintiff had approached the SDM and claimed that they got the land through government pacha but the plaintiff had not whispered a word with regard to issuance of government pacha in the pleadings. The court recorded that the plaintiffs have changed their stand before the court and also changed the basis of their claim with respect to the suit property. The court recorded that the land was Gair Majurwa Khas of ex-landlord before coming into force of Bihar Land Reforms Act, and therefore the suit vested in the state of Bihar. And the plaintiff has failed to establish and prove that the land in suit was validly settled to them in the year 1941. The learned court referred to Exhibit B, which is the notification, and was of the view that the notification could not be disbelieved on any score. The court also considered that the land was physically examined by Advocate Commissioner, who had submitted a report, Exhibit 10. According to him, 61.25 acres of land was in possession of the plaintiff, and he found house, trees, and well situated thereon. The court was of the view that it is well settled principle of law that an entry without an authority of law is nullity, and the person cannot claim his right, title, and interest on such basis. The court was of the view that since the basis of the claim of the plaintiff was under cloud, the pleader commissioner's report was of no help to the plaintiff, and also observed that documentary evidence would exclude the oral evidence. The learned court ultimately held that the plaintiff has failed to prove and establish their claim with respect to the land by way of settlement through Hukumnama in their favor in the year 1941, and held that the plaintiff had no subsisting right, title, and interest over the land, and decided the core issue, that is issue number 5, against the plaintiff. Issue number 3 was with regard to legality and validity of the declaration under Section 29, 30, and 31 of the Indian Forest Act. The same was also decided against the plaintiff. the learned court recorded that. Issue number 3, the learned court recorded that the plaintiff had not claimed right, title and interest on the basis of adverse possession. The court also recorded that ultimately the learned court dismissed the suit primarily on the ground that the plaintiff has not been able to prove his title over the property. The learned first appellate court has also considered the materials on record and has recorded concurrent findings. And ultimately dismiss the appeal. The court had formulated a point in para 9 that the only question which emerged was as to whether the judgment of the trial court was justified, legal and sustainable. The learned court recorded the findings as under page number 11 of the appellate court judgment. यहाँ से take करेंगे. On scanning of anatomy of the entire records. Mark करती हूँ. This court finds that the learned court have given concurrent findings and the plaintiff has failed to prove his title with respect to the suit property on the basis of hukumnama, unregistered hukumnama and zamindari rent receipt. Since the plaintiff failed to prove his title with respect to the suit property and there are concurrent findings recorded by both the courts, this court finds that there is no substantial question of law involved in this case, which is accordingly dismissed.
Order Chapter 5, Second Appeal 160 of 2009.
Sorry?
13 days delay was there, but finally appeal. And this I declined for continuing the delay of 13 days.
Notice has been issued.
My lord. All these have been
Any objection for confirmation of delay? Compromise petition.
my lord. Both departments have
सब्स्टिट्यूशन सब कंप्लीट है. आपका आईए नंबर बताएंगे. यस.
Those are not. IA number 3254 of 2009. Limitation
3254
my lord. Of 2009 my lord.
2009.
My lord. Limitation
2009 से क्या चल रहा है यहाँ?
ये भी हो गया था. बाद में तो लिमिटेशन कंट्रोल नहीं हुआ.
आईए नंबर 3254 of 2009. Learned counsel for the appellant has submitted that this petition has been filed for condonation of delay of 13 days in referring the memo of appeal. He submits that the delay was unintentional as कहाँ रीजन लिखे हैं? And has referred to paragraph 3 and 4 of the interlocutory application. And has stated that the appellant number 2 remained ill during the period from 15/6/2009 to 10/7/2009. A doctor's report has been enclosed along with the interlocutory application. The learned counsel for the respondents has no objection so far as condonation of delay is concerned. After hearing the counsel for the parties, the petition seeking condonation of delay is in read. अब compromise petition. क्या मैटर है जो compromise करनी है आपको?
Attitude was my side. One exam then. Mother's management told
Appellant number 2. क्या compromise किए हैं आपको? What is the terms of compromise? What amicable?
both are of the same village.
Okay. What is the terms of settlement? कहीं लिखे होंगे ना terms of settlement? कहाँ है आपका terms of settlement? बताइए. तो फिर क्या compromise? You want to withdraw this appeal? What compromise?
But they have, themselves have settled this matter.
Settle means what? Then you withdraw the appeal. Settle means what? What is the terms of settlement? बिना terms of settlement के कौन सा settlement हुआ? कुछ तो बताएंगे ना? नहीं तो आप विड्रॉ कर लीजिए अपनी, सेटल कर दिया, बहुत खुशी की बात है, आराम से रहिए। नहीं समझ आ रही बात। What is the terms of settlement?
वो लोग अपना लेन देन कर लिए हैं।
क्या लेन देन कर लिए हैं?
देखो, मैंने लिखे नहीं हैं लेकिन।
आप प्लेंटिफ हैं? कौन?
हाँ, प्लेंटिफ।
एपीलेट कोर्ट से डिसाइड कर दिया था जजमेंट।
पार्टी मीटिंग के हमारे पास में बाद में डिस्कस कर दिया।
पार्टली डिक्री किया था ना, फर्स्ट एपीलेट कोर्ट तो सेटिसाइड कर दिया था जजमेंट। पार्टली डिक्री किसके फेवर में किया था?
प्लेंटिफ नंबर 2 प्लेंटिफ नंबर 2 के फेवर में किया था। यहाँ पर एप्लीकेंट नंबर 2
जो यहाँ पे अपीलेंट नंबर 2। अब किसकी तरफ से? सारे रिस्पॉन्डेंट्स की तरफ से। सारे रिस्पॉन्डेंट्स का वकालतनामा फाइल किए हैं। पैरा नंबर 7 देखिए। जुल्फकार, क्या वो रिस्पॉन्ड नंबर कौन है? जुल्फकार,
ये
रिस्पॉन्डेंट नंबर कौन है?
नंबर 1 son के son. He is the grandson of respondent 1. जहाँ भी चला था.
नहीं जान, ठीक. Learned counsel for the parties are present. And the learned counsel for the parties jointly submit that the second appeal be disposed of in terms of compromise, which has been brought on record by IA number 10906 of 2025. It has been further submitted that along with the interlocutory application, wakalatnama of all the respondents have also been filed by the learned counsel for the respondents, namely, नाम बताइए अपना, Ganesh Ram, who is present in the court. They have referred to paragraph number 7 of the interlocutory application. Paragraph 7 of the interlocutory application is quoted as under. In view of the joint submission made by the learned counsel for the parties, this appeal is disposed of in terms of therefore say compromise. Let IA number 10906 of 25 form a part of the compromise.
Item 6, second appeal 93 of 2011.
Impute judgment को satisfied करना पड़ेगा ना? Consequently, the impute judgment and decreases as is equal to the compromise between the parties. Other way.
ID number 13996 of 21.
Who died when?
Respondent number 1 died on 3rd of February 2025. Mention in paragraph number 2.
When did you file it? 9/10.
There is a delay of 1 minute.
Notice has to go. Notice has to go. I number 13996 in SA number 93 of 2011. This petition has been filed for substitution of respondent number 1, who is said to have expired on 3/2/25. What's that? Or the date is?
14/7/25.
वो ना अदर्स को नोटिस नहीं करने का ऑर्डर, प्रोफॉर्मा को नोटिस नहीं करने का ऑर्डर. A prayer has been made for condonation of delay and also for setting aside abatement. Issue notice to the proposed legal heirs and successors of respondent number 1, namely Janam Salim Sahib. The names of legal heirs and successors have been given in paragraph 3 of the interlocutory application. Through speed post, the requisites will be filed within 1 week. This is an admitted appeal.
And
Admitted. Office to track speed post delivery.
The name is Janab Salim Sahib.
जनाब, मैंने क्या बोल दिया? जनाब सलीम साहिब. स्पीड पोस्ट से कर दीजिए, मेन अपील में भी कर दीजिए, इंक्लूडिंग इन द मेन अपील, सब्स्टिट्यूशन एंड मेन अपील दोनों में कर दीजिए. इतना छोटा सा क्वेश्चन ऑफ लॉ है, इसके लिए तो कितना परेशान. Respondents are not appearing. He is the only contesting respondent. Is he the only contesting respondent?
Yes.
Alright, he is the plaintiff. Post on 1st December. Waiting service. Records have been received,
yes,
but nobody is appearing for the respondent. Nobody has entered appearance because the only contesting respondent has expired.
Item 7, second April 37 of 2012.
Yes.
I was texting was telling us that notice of report it is in marriage already.
Who died when? Who
This
died when?
was respondent number 1, Rajesh Kumar Adak.
When did he die?
6 December 2024.
Which is within time.
Yes, already, sir.
Whom are you representing?
Yeah, Worship, I have filed a Karadma for respondent number 125. So the substituted respondents.
Okay. But notice is complete, no?
Yes, sir.
So we don't bother who appears and who do not appear, right?
Respondent 6 and 7 are brought.
Let them not appear, we don't bother about it. Notice is served, that is sufficient.
Your Worship, from their side, the brother has taken notice.
ID number 46 of 25 in SA number 37 of 2012. This petition has been filed for substitution of respondent number 1, Rajesh Kumar Rajak, who is said to have expired on 6th of December 24. The petition has been filed on time. Notices were issued upon the proposed legal heirs and successors. And they have been served as per the office note. Respondent number 1 within bracket Roman 1, 2 1 within bracket Roman 5, and 2 have appeared by filing wakalatnama. Notice upon respondent number 3 has also been served. Any objection?
There is no respondent to your object.
यहाँ पे तो यही लिखा है. Respond number 3.
There was only one respondent, Rajesh Kumar Rajat, who was
No, there are other respondents also added by orders passed by this court. Right? You take care of this. It has been inserted. Counsel for the appearing respondents has no objection so far as the prayer for substitution is concerned. Considering the submissions, the IA number 46 of 25 is allowed. Counsel for the appellant is directed to delete the name of respondent number 1 from the first title and insert the names of legal heirs and successors whose details have been mentioned in the interrogatory application at para number 2. अब क्या है? Service is complete. So what is to be done now? The substantial question of law has been framed. No. 2012 से चल रहा है. 1 decade. It is an admitted case. You are not aware. Admit whether the finding of the lower appellate court that the plaintiff respondent has failed to prove that she has ever communicated the change of ownership of the अब बस शुरू हो जाएगी. Specific performance है ना? Tenancy का. You must have claimed title. Then so you are we tomorrow?
next week.
Next week. I have not seen tomorrow also. You have seen the next week. No. आपके कौन है senior? So
He's out of session.
records आ गया इसका. It's a short matter. Notes बनाएंगे.
Monday रख दिया जाए. Tuesday रख दिया जाए. Any time next week.
बताइए तो कौन सा दिन? शुभ दिन बताइए इनके लिए. Concurrent findings. आपको तो पता ही नहीं है कि एडमिट हुआ. क्या बोले? हाँ? मंडे रखते हैं. Post this case for final disposal on Monday. कल मंडे को 10:30 बजे रखे हैं है ना? उसके बाद होगा. उसके बाद होगा ये. ठीक है. अगर मंडे को नहीं टेकअप होता बाय एनी चांस तो ट्यूसडे को. Yes. There is a direction of the Supreme Court to expedite the hearing of cases relating to specific performance, landlord-tenant relationship, and these are short matters. And law is primarily settled so far as these aspects are. Notes बनाएंगे? Notes बनाएंगे आप क्या करेंगे? Short time. Weekend है. Short time कहाँ है? Weekend है. फाइल करने की जरूरत नहीं है, उस दिन लेके आएंगे.